An American think tank says over the past 10 years, Indians have stashed over $400 billion in black money abroad. Now, estimates may vary, but the size of the problem cannot be undermined. PILs have been filed, special investigative teams formed, amnesty schemes offered, and now a new offensive is being launched. A new law that goes after undisclosed foreign income and assets of Indian residents. Will it succeed where others have failed? Ayush Elavadi finds out.
We have taken a considered decision to enact a comprehensive new law on black money to deal with monies which are stashed abroad. To this intent, I propose to introduce the bill in the current session of Parliament.
If passed, the Undisclosed Foreign Income and Assets Imposition of Tax Bill 2015 will apply from assessment year 2016-17. The bill provides for separate taxation of any undisclosed foreign income and assets, even though these are to be reported under the current income tax law as well. But the UFIA bill goes a step further to levy a straight 30% tax and penalties of up to 3 times the tax. A one-time compliance window has been provided for taxpayers to come clean, and this may protect them from criminal prosecution.
You see, this bill has got 3 different parts. One is where the department knows that a person has got a foreign income or assets. To such persons, this law will not be applicable, and they will be governed by the Income Tax Act as it is. Then we shall have a second group of persons who would like to avail of the compliance window and voluntarily disclose their foreign income and assets and pay tax at the rate of 30% and penalty at the rate of 30%. So total, they will have to pay 60% of the income, and there will be no other penalty, etc. for them. The third category will be that those people to whom the department has no knowledge, and they also do not avail of the compliance window, which may be opened by the government for 3 to 6 months. Those people will be dealt with very severely under this law. They will be levied tax penalty 3 times and maybe even prosecuted.
Here you're looking at a situation where in addition to the value of the asset, you effectively have to pay incremental tax. And here we are not even talking about income in respect of the asset. You're actually talking about the pure play, whatever is the value of the asset, and in addition to that, a 3x the value of the assets that you have to pay tax on. I think and that is really the place where we sort of differ from what most other jurisdictions which have similar laws have in place, because I don't think any other country has this kind of stringent penalties which are there as far as potential non-disclosure is concerned, so much so that you go beyond the actual value of the asset.
These new provisions could have been brought in as amendments to the existing tax law, but the other laws, such as Prevention of Money Laundering Act, would have needed separate amendments. Will this anti-black money law succeed where the income tax provisions have failed? Already there are questions being raised about the implementation of several provisions. For instance, the wide definition of resident, low thresholds, the lack of a definition for financial interest, no clear guidelines on fair market value, the impact on intermediaries, and the stringent penalties. The UFIA bill has jurisdiction over any person resident in India. For individuals, residency is determined by the length of stay in India. For companies, it is determined by place of effective management. A new controversial provision in the finance bill says a foreign company would be deemed resident if its place of effective management was in India at any time of the year. Consequently, the UFIA may also cast too wide a net.
You have to read it along with the provisions under the Income Tax Act. So you have to actually take into consideration some of the issues around the new place of effective management as to when a foreign company can be treated as potentially a resident of India. And to that extent, you have to read both in conjunction together, even as far as the disclosure under this particular bill is concerned.
The UFIA bill defines undisclosed financial assets as one or more foreign bank accounts with a maximum aggregate balance of more than 5 lakh rupees in the previous year. Experts say that's too low a threshold and could lead to undue harassment by tax authorities.
even if somebody has, let's say, gone abroad, is doing an internship, unlike in India, let's say, you will end up having substantial assets. 5 lakh is really what? It's a $8,000 threshold that you're really looking at. If I do an internship, I'll probably get more money, which may be lying in the foreign bank account. And again, what you have to keep in mind is that from an income tax perspective, merely because having that amount does not mean I'm liable to tax in India. After I come back to India, if I earn any income from that particular amount, it is only in those circumstances I'm actually liable to tax in India. Second, from an exchange control perspective also, I'm allowed to keep that money outside of India and do whatever I want to do with that money. As long as I actually report the income which I actually derive from that particular asset that is there, those are really the only circumstances that today you would have actually been taxable in India. As opposed to it, you now have a situation that even if I have more than, let's say, $8,000 in my bank account abroad, I'm potentially subject to penalties and tax on the whole amount in case I fail to disclose it.
Let's take an instance of a person who's currently resident in India and he was a non-resident at one point in time. He may be a student as well, and he earned an income offshore, and he did not disclose that income in India because he was not resident for exchange control purposes, and he was not resident even for income tax purposes. I think that's a perfectly legitimate way of keeping income outside India, and I don't think that the bill is targeted towards those individuals as such.
The UFIA bill applies to both undisclosed foreign income and assets, and that includes financial interest in any entity. But financial interest has not been defined.
The challenge I think that all of us today have is that to what extent, whether it's direct or indirect, what are the kind of interests that are all covered? Issues such as being a beneficiary of a discretionary trust or a contingent beneficiaries. Under those circumstances also, does it mean that I necessarily have a financial interest? Those are still sort of gray areas really that are there today.
The UFIA bill says that Indians having undisclosed property abroad will have to pay tax and penalty on the basis of the current market value or fair market value of the asset, and not on the purchase price. But the question is, who determines fair market value of an asset in a foreign country?
First of all, it will be very difficult to determine what is fair market value. In India, the Income Tax Department has got the district valuation officers from the CPWD and other agencies who value such properties. But properties located abroad, some sort of mechanism will have to be found out to find out the fair market value.
Fair market value will be determined as it is determined for any other asset under the wealth tax law.
That leaves the most important question facing this law. Why will it succeed when others have failed? Experts point to the stringent penalty and punishment provisions. 30% tax with 3 times the amount in penalties. Up to 7 years of rigorous imprisonment for failure to furnish returns. And 10 years in jail for willful evasion. Worse still is the presumption of mens rea or guilty mind of the accused.
I don't look at it as a financial regulation. I look at it really as a criminal legislation really that is there today. And under criminal law, the basic tenet is that a person is innocent unless found guilty. Whereas here you're just shifting the complete burden of proof to say that, well, if the AO thinks that that is the case, you are effectively guilty unless you show me otherwise. And here again, a situation where the assessing officer has wide powers. Again, as I said, a wide overreach between what really was the objective and what you really see in the bill.
I think it will increase litigation, and except where people avail of the tax compliance window and pay 60%, where the matters are disputed, it will be a very prolonged litigation for the taxpayers as well as for the department, and possibly the recovery in terms of actual tax may not be very significant.
It's a tough act. There are no compounding or settlement provisions. If a company can't pay its penalties, its manager must. And a betterment by, say, a bank manager or an accountant could send him to jail for up to 7 years. The government is counting on this new era of exchange of information treaties and the threat of severe punishment to prompt disclosures. Will this treasure hunt hit gold, or will this be yet another attack of tax terrorism? In Mumbai, Ayush Elavadi.
Like we said, it's